The third big problem with corporate ownership is people think, I'm going to put it in a corporation, it'll be protected. Well, corporations are not bulletproof. It depends on how the entity is managed. Liability protection is not set it and forget it. And investors frequently forget about maintaining the corporate entity. You have to do minutes and have shareholder meetings and observe all of the corporate formalities. Otherwise, the courts will pierce the corporate veil. The other thing is there's inside liability, right? So there's things that happen on the premises. Tenant claims. I had a situation where a client got sued because somebody slipped and fell on her property and they sued her for $1 million. You have contractor vendor issues. Maybe there's negligent maintenance issues. These are all things that relate to the property itself, and that's called inside liability. So the corporation will protect against that, but you need to have proper contracts, operational formalities, which we just discussed, and really good insurance. Insurance is your first layer of defense. You're listening to Legacy Maker Podcast with Kristina Hess. Clear guidance for protecting your wealth, empowering your family, and creating a lasting legacy of generational impact. Legacy Maker, let's go. Real estate investors are told put it in a corporation for protection, but that advice can quietly cost you on taxes, exits, and inheritance. In today's episode of Legacy Maker, I'm going to explain to you why owning real estate in a corporation is often the worst structure and what to use instead. This content is for general educational purposes only and does not constitute legal or tax advice. Facts and jurisdiction matter. I'm attorney Kristina Hess with over 25 years of experience and the host of Legacy Maker. Welcome to today's show. All right, so the big mistake. Let's take a fictitious real estate investor, Sam. So Sam has acquired $10 million in real estate, which is the good news. The bad news for Sam, unfortunately, is that he took title to the property in an S-Corp. And Sam had no idea that this actually was a bad thing until he visited his estate planning attorney. And then his estate planning attorney informed him that owning real estate in an S-Corp is the worst way. Now, to Sam's credit, 30, 40 years ago, many years ago, CPAs told all their clients to hold real estate in corporations. That was common practice. One of my CPA friends has informed me. Unfortunately, this is not a best practice, and this is actually a worst practice. Corporate ownership fails on the following: liability, taxes, exit, and legacy. So what are some of these mistakes? Some of the mistakes are, number one, assuming a corporation automatically equals strong asset protection. Number two, choosing an S-Corp for rental income and appreciation. Three, not planning for the exit. Can you say taxes, taxes, taxes? So let's dive right in. Exit and distribution. Why are corporations problematic? So number one is taxation. So you buy real estate and usually there's going to be an exit. You're either going to sell it, you're going to transfer it, you're going to distribute it out to the shareholders. If it's in a corporation, if it's taxed as a C-Corp, then anytime you sell it or transfer it, you're going to face double taxation. So what that means is the corporation is taxed at the corporate level of 21%, and then the distribution to the shareholder is again taxed at that individual shareholder's tax level. There's no clean exit out of corporate ownership of real estate. So corporations can trap the appreciation in the entity. Now, the S-Corp avoids the double taxation, but it doesn't handle or deal with the transfer tax problem. So with the S-Corp, even if you move the property out of the corporation, again, the IRS is going to deem this as a sale, and any appreciation on that property, and if you've been depreciating the property, you're going to have depreciation recapture. All of that gain is going to be taxed. Even if you didn't sell the property, you merely distributed it out to a shareholder, or you distributed it out because Sam came to the attorney and said, well, can't I just transfer my property out of the corporation? Won't that fix the problem? And sadly, the answer is no. So the second big problem with corporations, besides the transfer problem and the exit problem, is it's a mismatch for real estate strategy. So S-Corps are really useful if, let's say, you're a real estate agent. You sell and buy, you help people buy and sell homes, or you're a real estate broker, or you're a professional, like my business is an S-Corp. For active income earners who are actively earning income, an S-Corporation is a great structure because it minimizes the self-employment tax. But for real estate, which is a passive activity, it's not the best entity because what if you want to add partners? It's cumbersome in a corporation. You can't allocate cash flow among different members like you can with other entities. And then if you want to make changes over time. The third big problem with corporate ownership is people think, oh, I'm going to put it in a corporation, it'll be protected. Well, corporations are not bulletproof. It depends on how the entity is managed. Liability protection is not set it and forget it. And investors frequently forget about maintaining the corporate entity. You have to do minutes and have shareholder meetings and observe all of the corporate formalities. Otherwise, the courts will pierce the corporate veil. The other thing is there's inside liability, right? So there's things that happen on the premises, tenant claims. I had a situation where a client got sued because somebody slipped and fell on her property and they sued her for $1 million. You have contractor vendor issues. Maybe there's negligent maintenance issues. These are all things that relate to the property itself, and that's called inside liability. So the corporation will protect against that, but you need to have proper contracts, operational formalities, which we just discussed, and really good insurance. Insurance is your first layer of defense. And then if it's a single member entity, then the chances of the court piercing through to the single owner is very high, especially if, like me, you're in California. All right, the fourth problem is estate and legacy complications. So corporations can complicate transferring interest to heirs. And the big problem, the huge problem, the biggest problem of them all, in my opinion, is there's no step up in basis upon death. So for all of my clients and all of the Sams out there who own real estate that's appreciated, say Sam bought his rental property, it was a commercial building for $2 million. Now it's worth 10. He's got $8 million of appreciation. When he transfers that to his heirs, there is zero step up. So that means that those heirs are going to pay capital gains tax on $8 million. Now, if Sam was a 50% shareholder and he had other partners, maybe his wife was another shareholder, maybe there was over time maybe they added the kids as shareholders, whatever it is, if it's taxed as a partnership, then you can have a basis adjustment. Your accountant can do what's called a Section 754 basis election, and you can adjust the basis within the partnership upon death. You can't do that with a corporation. You can't do it with the C-Corp. You can't do it with an S-Corp. There is no basis adjustment on death, and so this is a huge failure, in my opinion, because there's massive capital gain if and when the property is going to be sold. The step up in basis is such a huge thing. So that outlines the problem, 4 easy steps, big problems. What's the solution? What should you use instead? So the easiest and the most common, and there's a reason why it's the most popular structure, is the LLC for real estate ownership, because better legacy planning integrates LLCs as well as different types of trusts. So the LLC is the baseline. LLCs are commonly used because you've got an operating agreement and then you've got flexible management and distributions. Typically, the members should not be the managers. You can have a third-party manager. You can have an entity as a manager. We don't usually want the members as the managers. That's a common mistake that I see people make. It's simple to admit new members, and you can enhance the asset protection in how you draft the operating agreement. So these are very important. The other thing is you can segregate risks. So a lot of our clients have multiple real estate entities, and generally, not always, but generally, you'll want to have each property in its own LLC. So each property is going to be owned in its own LLC. And some states like Nevada, and there's other states that will allow series LLCs. So if you're in a community property state, for example, and a husband and wife own the real estate, it can be taxed as a disregarded entity. But then over that, you're going to have a layer, which is a holding company. So you're going to have a holding company, and then you're going to have LLCs, either series LLCs or individual LLCs for each property. And my favorite jurisdiction for the holding company LLC is, of course, Wyoming. Wyoming, why Wyoming? Wyoming is wonderful because it's the most private. It has the best asset protection. You can have charging order as the sole remedy, even if it's a single member LLC in Wyoming. For those of you who live in California, California is one of the worst jurisdictions. Now, you might, if you own real estate in California, you may have a California LLC as the underlying owner, but then you're going to have a Wyoming holding company to hold that California LLC to get those Wyoming protections. Because California, you're not limited to the charging order because debtors and creditors can actually foreclose on your LLC interest and then they become a member of your LLC. So that's again where drafting your operating agreement is going to be very important. And then it's also going to be important to have a Wyoming closed LLC as your holding company. So this can segregate your risk. And then we can also layer in, you can have, the holding company is going to be the parent, and you can have separate property LLCs, as I mentioned underneath. And then you're going to layer that with revocable and irrevocable trusts based on the complexity of your estate, who owns what, have you done any dynasty trust or gifting trust, or if you're in California and you want to effectuate avoiding property tax reassessment, then there's some creative strategies we can use with LLCs and irrevocable trusts. So for all these reasons, the LLC and the trusts are the best structure to own real estate. You don't want to own real estate in a corporation. Hopefully by now that's abundantly clear. Now, just be advised that never is an absolute term that lawyers typically do not want to use, because the first thing you learn in law school is it depends. What's the answer to every legal question? It depends. It depends on the facts. It depends on the application of the facts to the law. It depends on the jurisdiction, because real estate is governed by the jurisdiction where it's held. So this particular episode is more applicable only to people who live in the United States. And there's narrow exceptions. There could be a certain situation where owning real estate in a corporation makes sense because maybe it's a short-term investment. Maybe it's, there could be reasons. But generally, for most real estate investors, for most legacy makers, doesn't make sense at all. All right, so if you want a one-page real estate guide, just let us know. Go to legacymakerpodcast.com, reach out to us, ask for our free guide on the best way to own real estate. Investing in real estate is a wonderful way to build wealth, and it's a big part of being a legacy maker. I personally love real estate. My dad was in real estate. We were in real estate growing up. But ownership structure matters. Structure is not a one-time decision, it's a legacy decision. If the goal is asset protection and generational transfer, the entity must match the strategy, especially the exit. So in future episodes, we'll be talking about some of the more nitty-gritty on how you can structure the operating agreement for your heirs and succession planning, and to avoid divorce situations and control issues. But hopefully you've gotten a lot out of this episode. And if you have friends that invest in real estate, be sure to share this episode of Legacy Maker with them, and they will thank you. Thanks for joining me today. When you're ready to take the next step, connect with us at legacymakerpodcast.com. And until next time, stay wise, stay intentional, stay a legacy maker.